there for you. All right. So with that, let us begin. Question number one is pretty generic and general, but so what would you say are the most common mistakes people make in their estate planning? Maybe Brad, we'll start with you.
Sure. So there's quite a few, I guess, common mistakes in estate planning. Probably one of the biggest ones is just not addressing contingencies and not developing a will or an estate plan that sort of contemplates what might happen in the future, whether it's, if you only have one child, but you might have children in the future, you can set up your estate plan in a manner that contemplates having multiple children in the future. Or if it's not contemplating sort of the disaster scenarios that, we don't really want to think about or talk about, but for example, if your spouse and your children, sort of predecease you, what are your intentions with respect to your estate? So not covering, various scenarios is a big one. Other big ones I would say are people who name non-residents as executors. That can be a fairly big issue. And then another one is second marriages, and sort of figuring out how to navigate that, where you want to, obviously provide for your spouse, but also usually protect the assets for your children as well.
Okay. Yeah, I'd agree with that, Brad. And it's the sort of more common things I see too. Having an up-to-date will and estate plan is probably the most important piece. Up-to-date is so key because, again, things change in your lifetime. So if we're entering a second marriage situation now, obviously your intentions probably have changed in terms of where the assets are going and how they're going and which ones are going to, which people, and making sure that's properly communicated. You don't want to leave sort of a ticking time bomb to the family to say, okay, no one knows what I'm doing. They just open the will and see it, and then everybody sort of gets at odds and causes problems. And also, legal things change all the time. Tax changes are always present. So if we're not constantly updating a plan, we may not be getting the most tax advantaged plan for the family kind of going forward. So it's really key, I think, to keep a good pulse on what's going on and to check in with the person who drafted your will every few years to make sure it still reflects your intentions and it's up to date and it's reflected any current changes in any legislation that might have an impact on your planning.
Awesome. Great point. Quick question back to you, Brad. What did you mean by non-resident? Question from Tim.
So non-resident, in this scenario, I'm primarily referring to somebody who lives outside of the country. Ideally, if you live in Ontario, absolutely ideally, your executors would also live in Ontario, though, people from other provinces within Canada, that doesn't usually create too many problems. But if you have a US person named as the executor or somebody from Europe or something like that, it can lead to a number of issues.
Okay. So question I got earlier is, how do you know if your will is good or if your will is okay? How would you know what the state of your will is? Maybe Brad, start with you.
Well, I think Kody sort of mentioned this in that you should just sort of keep in touch with, whoever helped you put together your estate plan, every so often. So we usually send out letters to our clients every 3 years or so, just to give them sort of a reminder. And from our end, there's sort of a checklist, like, have there been any significant changes in your life? Do you have new kids? Have you gotten divorced? Have you gotten married? Things of that nature. And we also flag changes in the law. But from your perspective, if you haven't had any ongoing conversations with a lawyer or an accountant or somebody who helped you with your estate plan, I would just say reach out to them and also review your will, every few years yourself and see if it still reflects what you want.
And is the best way to do that to change as things change the will as things change, or to add things onto the end of the will?
So for minor changes, we can do what's called a codicil, which is essentially it's a legal amendment to a will, and we can do that. It's relatively straightforward. It can be as short as 1 page or a couple pages. But if you're doing significant changes, you probably want to just do a whole new will.
Okay, sounds good. So let's move on to taxes. What taxes, to begin with, are due upon death? Is there an inheritance tax in Ontario and Canada? And what are things that people can do to reduce the size of the tax burden on their estate? Maybe Kody, we'll start with you.
Pretty good, all-encompassing kind of question for the tax world on passing. So maybe I'll give a a sort of brief synopsis of what happens on death and some of the things we do for people as we're planning for that to minimize the bill, because that obviously is where we come into the equation, is, you know, dealing with people through their lifetimes and figuring out what's the potential exposure we have here and how do we minimize that exposure and leave more to the family and pay less to CRA in a legal manner, obviously. So the biggest thing that happens is when somebody passes away, there's basically a deemed disposition of all of their assets. Okay, so anything they have right now that has an accrued gain on it brings in tax. The biggest piece usually is the RIF. So a RIF is fully taxable in the year of death. Any sort of real estate, like a second home, a cottage, things like that, all become taxable. The principal residence is exempt from taxation. So there's no tax on any kind of accrued gains in principal residences, which is really good. There's been some chatter with finance about, are they going to change that in the near future? And you know, I don't think they are personally, but it's something they're certainly looking at because the deficit is just so large for the country right now. They're looking at all different kinds of ways that they can get a bit more tax. But in a nutshell, you've got the income tax on passing. You've got probate, which isn't necessarily a tax; it's more of a fee. I do tell people. So probate applies on some value of the assets. There's some planning you can do around having dual wills. So if you've got shares in a corporation, we can potentially avoid some probate there. If we've got named beneficiaries on some of the assets, we can also potentially avoid probate there. And Brad, correct me if I'm wrong, but I'm pretty sure Ontario has one of, if not the highest, probate rates in the country, unfortunately. So we're stuck with some pretty high rates.
Yeah, it is on the higher end, but at the same time, it's 1.5% the value of the assets of your estate. So it's not like it's a 30% tax or anything like that. But you know, depending on the value of your estate, that can still add up to quite a significant amount of money.
Yeah. And so those are the two big ones to worry about. There's no inheritance tax necessarily that they have in the US and other countries around the world. Ours is simply an income tax. The income tax is avoidable if things transfer to a spouse. So if you're the first to die, generally what happens is we say you should leave most of your assets to your spouse, especially the ones that would have any kind of income tax implication. That should be going to the spouse. So when we're doing any kind of planning like that, we're trying to figure out what the wishes are of the person. So if they're the first to go, what assets do they want to transfer to potentially kids versus the spouse? And there's assets going to the kids. We want to make sure it's not taxable assets. So it's something that's not going to attract a huge tax bill, because anything that goes from the parent to a child would be taxable. Or if it's the second to die in a couple, that all becomes taxable as well. So that's part of the estate planning. And then the ongoing strategy we use for people is, we know there's going to be, again, a tax liability. How do we take care of that during someone's lifetime? One simple strategy might be, okay, we know the RIF is going to be fully taxable on death. We've got some shares with accrued gains outside of the RIF world. We know the capital gain is 50% included right now versus the RIF being 100% included. So maybe it makes more sense to draw down the RIF as far as we can, so we clear that out to avoid having a huge tax bill on that. So often what I find with people is they don't realize the RIF is a taxable account. So when the second to die goes, the kids are saying, okay, well, there's 500,000 left in the RIF. That's great news. We get $500,000 for the family. No, you're probably paying close to half that in taxes, which is, you know, basically just wasted money at that point, and you're left with whatever the residual is after you pay the tax man. So I think that addresses a lot of the questions in there. I don't know, Brad, if you want to add anything, or if I missed anything from some of those questions that came up.
Well, it's a very broad topic, so I think you covered it pretty well. I think a few other additional comments would be, you know, from the probate side of things, we can often avoid probate entirely on the death of the first spouse. I don't know how much detail I should be getting into, but essentially, probates, it's not a mandatory, you know, tax. It's like Kody said, it's referred to as a fee, and it's the fee that the court charges when you go through the courts to certify a will. If, for example, you have two spouses and, you know, almost all their assets are jointly held, and on the registered accounts, there's a beneficiary designated, you know, usually the spouse, then those assets are actually flowing pursuant to, you know, the right of survivorship under the joint designation of you know, the house or the accounts that are jointly held, and then or under the beneficiary designation. So when the first spouse passes, like technically very little can end up passing under the will, and you can avoid probate if you've sort of planned enough in advance for that. And then just sort of to reiterate something that Kody was saying, you know, a lot of the sort of estate planning, it's not just putting together your will, but it's thinking about strategies to, while you're still alive, to reduce your tax burden. So he gave the example of, potentially depleting your RIF instead of other assets while you're still alive to reduce your tax burden. And then I guess one final comment would be charitable donations also come with a tax receipt. So whether you do that while you're alive or if it's something that you put as part of sort of a legacy planning that you have in your will, that's something that can provide a tax receipt to your estate and reduce the tax burden on death.
Awesome. Thank you. Okay, I'm sure there'll be questions sort of down the road in terms of taxation, but let's move on to trusts. When is a trust the best thing? When is a will the best thing? When would you sort of, incorporate a trust to be able to, reduce or to sort of improve things for your loved ones after your passing?
Yeah, I can hop on that one first if you want, Brad, and give my 2 cents on it. So there's a few different kinds of trusts. So I don't know which one specifically the person was referring to, but that's fine. I'll talk about a couple different ones right now.
There's one mention of the Henson Trust, just to interrupt for a second, but you can factor that into your answer.
Yeah, so Henson Trust is actually a very specific kind of trust for somebody that has a disability. So it's a great planning tool if you've got an adult child that has a disability. It's a great way to manage the assets so they don't lose entitlement to their ODSP they typically get, the tax-free payment from the government. The most common we see are a testamentary trust, which basically gets formed on somebody's passing. And what that does basically is instead of the assets going to individuals, it goes to this testamentary trust and it gets managed there. There's a couple benefits of doing that. One is you get a preferential tax rate for the first 3 years now. It used to be a lot longer, but they capped that a few years ago. Now it's only 3 years, but it's still a good benefit to have. And then the big reason you like to have a trust usually is control. So if you don't want the assets to go to the beneficiaries directly, having a trust gives you some flexibility in terms of how that asset gets managed. And you would assign a trustee that would be in charge of basically passing out those assets, determining the income and seeing where the income goes in any given year. The other trust you see is an inter vivos trust. An inter vivos trust is established during someone's lifetime. And we use that quite a bit in our planning for some of the same reasons. One, it gives you a lot of flexibility with assets. So you may have an investment portfolio. You say you don't really have a need for this. I want to establish an account for the children. Maybe you could put it in a family trust and you could manage it that way. Again, there's trustees involved that oversee the management of the assets, the distribution of the assets, and how the income gets reported. So that's a really nice thing. It also then can reduce the estate tax burden. So the estate tax burden we talked about before and said, hey, if we've got these assets that are accruing over a lifetime, eventually when the second to die occurs, we've then got this taxable transaction. If we move assets to a trust instead, the trust is a separate person from the individual we're talking about. So if something happens to the individual in that case, well, it doesn't matter quite as much because the trust is the one that has the value and not the individual. So it's a really great estate planning tool we can use for people, and one we use really often if there's any shares of a private corporation. So any kind of business owner, we almost always recommend a family trust should be involved. It achieves a ton of benefits. Liability exposure is another one. And then even if there's no private company, we often say, okay, if there's a big enough investment portfolio, it may make sense to move some assets to an inter vivos trust at that point in time. And then we can also have control over how the income gets reported, who reports the income, and ultimately we get control over the growth in the assets. We pull it away from the individual and we put the trust instead, and potentially the kids kind of down the road. So those are the two most common. The Henson gets another really great one if there's a disability in the family. You can set up a trust for someone on that front. And there's a couple more that are a bit more specific. The alter ego trust is another one. Little less benefit, I'd say, from that. Probate avoidance is one of them. And then you're just getting the assets again out of your name, so it doesn't show up in any kind of search, which can be helpful sometime. That's my spiel on trusts.
Yeah, and I guess just to add to that, whether a trust is right for you, it's very fact and circumstance dependent. So there's not going to be a type of trust that's beneficial for everyone. When it comes to testamentary trusts, some big ones, the Henson Trust was mentioned. So that's if you have somebody, a beneficiary who has a disability, and they have entitlements to ODSP. So that's a type of trust that can provide sort of additional funding for them, but that doesn't sort of breach any of the requirements for ODSP. But other, very common trusts are like they're simple trusts. But if you have beneficiaries who are minors, if you have a 12-year-old grandchild or child that you want to leave some money to, they can't take that outright to begin with. So if you don't put any trust wording in, then technically it needs to be paid into the court where they hold it on their behalf until they turn 18. But even, when a minor turns 18, you don't necessarily want them to receive a large inheritance. They're probably not going to spend it, in the most efficient manner. So we often put in trust wording that sort of provides for the executor or a different trustee to sort of help manage the finances, like the inheritance up until a certain age where the beneficiary would presumably be more responsible and able to deal with an inheritance of that magnitude. And then I guess another common one, we briefly discussed sort of second marriages, and a spousal trust is a way that you can provide for a spouse, where there's a trust that provides, funding for them and income for them during their lifetime, but ultimately you can protect the capital of the trust for the benefit of your children. And then going to intervivalist trusts, I don't think I have too much to add. It's, like Kody said, there's a few different options. It's very dependent on circumstances. A lot of what Kody does is sort of in the estate freeze world, where you're trying to, protect the growth in value in a corporation, protect it from capital gains on your death. But something else that other people often use family trust for are the family cottage. So if it's a residence that you can't really use the principal residence exemption on because you don't actually live there, doing some planning in advance for the cottage can be something to look into. The cottage, though, is always a difficult one. There's, as you go down the generations, there's usually more and more people, and it's hard to divide that amongst so many people.
So how do you do? Like, what's the best way? Is there anything that you can do sort of to prepare that? For
the family cottage?
Yeah.
So the family cottage is sort of referred to as the dreaded family cottage when it comes to estate planning. It just gets more difficult as you go down sort of the list. So the easiest, ideally, if it's a small family and there's only a couple children, then it's usually not too problematic as long as they get along. But if you have a large family, if you have 5 or 6 children and, your cottage is in Ontario, but 2 of your children live in, BC or out west or, in the US or something like that, then you might want to look into a way where the cottage goes to a certain subsection of your children, but you're accounting for that in your estate planning, where the other children are getting a higher share of, other parts of the estate. So, there's different approaches, but it's going to depend on circumstances.
What about other assets or assets in other jurisdictions? House in Florida or whatever those other things might be. How do you sort of prepare or manage that if it's outside of, the area in which you live?
So I can jump on this one. So in certain situations, it's going to make sense to have multiple wills. So you don't have to have just one will. You can have, one will that deals with just your Ontario assets, or another will, that just deals with a cottage in Quebec. And the benefit to doing that, so just to give a bit of context, so when you die, I mentioned the probate process earlier and how you often have to apply to court to get the will certified by the court. So that takes time and it takes money to do. Usually it takes at minimum, 3-4 months to obtain the probated certificate, but it can take quite a bit longer. And if you have 2 wills, you can sort of deal with, the cottage and
You frozen?
and
when you're back. You're frozen for a second.
Was I frozen?
Yeah, or maybe I was. It's usually me. Anyway, keep going.
Okay, well, I was just going to say, and when you probate a will in Ontario, if you have to use that will in another jurisdiction, you usually have to go through their court process as well and reseal the will in that jurisdiction. So you end up having to jump through a few extra hoops if you only have one will in certain circumstances. In Quebec, for example, you can use what's called a notarial will, which is pretty easy to set up, and those can be used without having to go through the Quebec equivalent of the probate process. So if you have assets in Quebec that you want to deal with, it can be a lot more efficient to have a second will in that province.
One thing I would add to that, what I typically see for our clients, but just how close we are to the States, is usually people have vacation properties in the US. That's usually what we're trying to deal with when it's outside Canada. I have a few, spread around, some in Italy and over in Europe and places, but majority have places in the States. The States has an estate tax. So if you hold that asset personally and you have a significant amount of wealth, even if that wealth is in Canada, you technically are trapped by state tax rules in the US, even though you only have the one asset there. So what we typically advise people of is if you've got an asset outside of Canada, specifically in the US, we may want to look at a separate structure to hold that property, or make sure the plan is to dispose of that asset before the second to die if possible, to make sure we don't walk into a huge tax liability in a foreign jurisdiction that was easily avoidable.
Okay. The question here from Danielle is in terms of reducing capital gains. So if you've got a second property that you're looking to sell, to minimize capital gains, should she transfer it to her daughter, her only child? Is that a best practice? Am I frozen? Oh.
Okay.
I was frozen there. Are we talking about assets that are back in Canada again? Or are we still talking about foreign assets?
I think we're talking back in Canada. My guess.
Yeah.
Is.
Okay. That's what I figured. So I think that goes back to Brad's comment before about the family cottage, and it's the biggest issue I see with clients too. And it's honestly, it's never really a good discussion because it never goes well. Nobody ever agrees on what the plan is. But one of the ways we look to minimize that tax is, okay, we know we've got this accrued gain on a cottage. We can transfer to a child now. We do have to pay tax on that transfer though. So whatever the value is today, we can transfer it now. Some clients are still saying, you know what, I think it's still worth it to do that for two reasons. One, you lock in the capital gains inclusion rate, which is 50% right now. So it's only half taxable, lowest it's ever been. There's a good chance it's going up in the next budget next year. Two, you lock in that tax liability overall. If the cottage is worth $500,000 now, we can sell it to the next generation now, pay the tax on that transfer. The cottage goes up to $750,000. Well, that's okay. Then now the extra $250,000 growth is in the child's name, who's a lot younger, and not the parent's name. So we've minimized our exposure on income tax. So we're in a better position overall because of that. And that is one of the solutions we get with the cottage. So there's a couple. One, I think Brad touched on, is you can set a family trust up to hold the cottage, and that trust agreement can deal with the upkeep, the maintenance, the use. It can address all those kinds of issues. Two is you can roll it to a corporation. You can have a corporation manage the trust. It's similar in a lot of respects. And then you can have either trust own that, or you can have the siblings, I guess, in that case, or the parents as the owners, or you could just sell it out right now. And you could say, okay, we know child one is the one that wants a cottage. Children 2 and 3 are either out of the country now, they've left Ottawa, so they don't have any need for this cottage anymore. And you can just equalize the rest of your estate based on the fact you're giving a cottage to one of the children. So lots of ways to deal with it. And honestly, the one we're seeing often now too is the parents are saying, we're just going to sell it. We're going to sell it before we go because it's causing too many issues. Nobody really wants the cottage. They all kind of half want it, but don't really want it. No one wants to pay for the upkeep. No one wants to deal with all the issues of the cottage. We're going to sell it before we go, and we get old enough we can't really enjoy it anymore. And then we'll just have the after-tax cash. We'll split that amongst the kids instead.
Yeah, and I guess the only thing I would add to that is it sort of like Kody said, when you're going to the next generation, you're triggering that capital gain. So whether it's while you're alive or it's after your death, you're going to have that capital gain to deal with. You can, there are spousal rollovers, so it can, transfer to spouse without triggering a capital gain. But once you go to that next generation, you're going to have to pay that capital gain at some point.
Okay. How about we move on to people thinking around executors? So what are your recommendations in deciding upon an executor? And specifically, after you die and the person who is your executor realizes they're not up for the job, then what?
So I can jump into this one, Kody, and then you can add some comments at the end. I would say, people frequently will want to name their spouse as the first option, and that makes a lot of sense. I think in most circumstances, they're the one who is going to know, your assets probably more intimately than anyone, know your circumstances, know your intentions. Often people will also put their children, and they'll often put all of their children. That can be fine, but it can also lead to significant problems. So I think you need to have a pretty good pulse on sort of the relationships between whether it's your children or even if it's other people, but the relationships between the people that you want to name as executors, if your plan is to name multiple executors. So you want people who can get along. You also want ideally to have some kind of tiebreaker mechanism. So for example, if you only have two executors and they disagree, that can be problematic. So you can build in language sometimes where there's a third party who can help them if there is a disagreement. But at the end of the day, like I find that having a single executor is sort of the most efficient way to deal with things. You just have the one person who has to sign everything, the one person make decisions. But that can also lead to tension. So if you have three children and you name one child, then the other two can feel slighted. So there's no perfect answer. There is also the option of using a professional executor. They tend to, I think, help things run quite smoothly. All the major banks have trust companies that can provide executor services. There's obviously a fee involved, but they generally run things pretty smoothly. They help keep tension to a minimal. So if you have sort of a family where you think there might be tension, or even if there's just nobody that you can think of who would be a good choice to be executor, professional services are also an option.
Okay. And if the person realizes they're not up for the task, then what?
So if they've already started acting, that can be problematic, because once you've started acting as an executor, you technically need a court order to be removed. So if somebody doesn't want to act, they should make that decision early on. If they resign or renounce their right to act, it would then fall to whoever was named, subsequently in the will as the alternate executor. And ideally, that's something that should be built in. Like we try and have at least a couple of alternates built in there. But say there's no alternates, then it's really falling to next of kin and the beneficiaries to sort of nominate somebody. And ideally everybody consents to the same person, and then if everybody consents to the same person, it's not really problematic. If there are disagreements in terms of who should be acting, then it would usually go by sort of spouse would have the first right, and then your sort of closest related relatives.
Okay.
Yeah, I read something recently that said, making somebody your executor is actually one of the worst things you can do for them, because it's such a challenging job. And I don't think people realize the amount of work that goes into it, and the dynamic you're stuck dealing with. So as you said, if you're one of three kids and you're the executor, trying to deal with that. If there's a second marriage and now one of the kids is trying to deal with that, and the person didn't properly alert people to what they were doing with their assets, it can create a lot of problems. So I think the key is to let people know, who the executor is going to be and why you've chosen that person. Don't leave it to the executor to be telling people they're the executor now after you've already gone. I mean, it's your responsibility to tell the family who you appointed and why, or if you've chosen, like Brad said, a trust company to do it, because they're totally independent. Third party can just manage the whole thing. And two is make as many of your wishes known during your lifetime as well. So if you're cutting, for example, one child out, or the second spouse out, or whatever the case may be, let people know about that during your lifetime, so it doesn't create a really uncomfortable situation for the executor when they take over the pieces after you pass away.
And I mean, we like to think that we're going to pass away sort of prepared for it, but situations obviously present themselves where you're not prepared for it, and then it's just left to the executor to kind of figure it out. So somebody who anybody of us that's on this call, or anybody anywhere, what can we do now today to just make sure that those things are in order, so that life is as easy as possible for the executor? Lists, making sure things are known where they are. Like, how can you make that transition as easy as possible on that person?
Well, like Kody said, it's a difficult burden. I think no matter what, even in a simple estate, there's quite a lot to sort through. I think depending on how much time you have to plan in advance, like if it's completely unexpected and you die at a young age, there's you maybe haven't put in as much planning in advance, but if it's something you're really thinking about, I think consolidating your assets can be helpful. Some people, the executor takes over, and then it turns out they have accounts with 4 or 5 different financial institutions. They have accounts in the US, accounts in Canada. They have maybe a house down in Florida that they've barely used for the last few years, but they still technically own it. So sort of consolidating assets, if it makes sense to do so, can be something that can be helpful. In terms of making lists, that's a difficult one, because ultimately your assets fluctuate quite a bit and can change pretty quickly. So I think it can be helpful to create a list, but if you're doing that, you do need to update it fairly regularly, and you also want your executor to be aware of where that list is. Digital assets is a big one. So it's not really too common in the estates that I've been dealing with, but I think it's because, people dealing with cryptocurrency as a generalization are probably on the younger side. But if you are somebody who has cryptocurrency or other digital assets that hold significant value, I think you really need to think about that in advance and make sure that whoever your executor is, they're going to have access to that when you pass.
Sounds good. So I got one more question, fairly specific one, and then I'm thinking I might just sort of open it up to everybody here. If there's a question that you kind of want to ask, this will be your chance to ask it. So get it ready. So the question is how to deal with banks and investment companies so that you have complete control over the accounts and use the funds of your spouse who is incapable of handling her own affairs. It appears that even having a POA with the bank still allow them to oversee and control any transaction they wish.
So that's, I guess, fairly broad question, because it's not necessarily clear what the banks are in this situation trying to control. But I think having a very clear power of attorney that provides signing authority to the power of attorney can be helpful. If you're having issues with a specific financial institution, if you're the power of attorney, you can look into transferring those assets to a different institution. Also, planning ahead of time, if it's a type of account, specifically if it's a spouse, but also with adult children, you can put each other, as joint account holders ahead of time. You can't do that with, an RSP or a RIF, but if it's just sort of a checking account or a non-registered investment account, those are the types of accounts that you can, put each other on as joint account holders. And people also put their children on as joint account holders, not in the true sense of it being a joint account, but in the sense of, just having somebody on there who can assist with administering things as you get older.
Yeah, the key there I would just bring up, because I see this quite a bit, is once you do that, know that the income from the account is still yours. So if you add like a child, let's say, to the bank account or the investment account, non-registered account, all the income belongs to you still. It does help with probate, and it does help with administration if you were to pass away. But I just make sure I bring that up, because people say, okay, well, my 2 kids are on the account as joint holders. We'll split the income 3 ways. The income's still yours, so you're still paying tax on all the income. What you're really doing is just making the administration process easier. So still worth it, but just keep that in mind. Nothing changed the taxability of the account. It's still your money and your funds and taxable in your hands.
Yeah, and I guess one additional comment. So on the probate issue, I mentioned, I think at the start of this call, that having accounts held jointly is a way that you can avoid paying probate, because technically the asset flows, from right of survivorship rather than flowing under the will. When it comes to naming your adult children as joint account holders on your account, there's a legal presumption that it's not a true joint account, and that it's really what's referred to as a resulting trust. So when you have adult children added on as joint account holders, that will not typically avoid probate for that asset. It usually still has to be included in your application to court, and you have to pay the 1.5% fee on that.
All right. So does anybody have any questions that they wanted to have answered? Anything that they heard today that they thought piqued their interest and would like to know more about. Does anybody have anything that they would like to ask?
If not, Trevor, I can give another sort of quick sort of income tax piece if everyone's okay with that. So there's three things I was going to mention. I don't think we've touched on yet really. One pertains to, you know, the family cottage or the investment property or some other piece of real estate outside of your tax exempt primary residence. What people often miss or forget is any costs that you incurred on that property over the years are added to your cost base. So it actually reduces the capital gain you'll pay down the road. So you paid $100,000 for a cottage 30 years ago. It's worth $500,000 now. That looks like a $400,000 gain. But if you put a new roof and a new deck, new siding, you put an extension on it, maybe you spent $150,000 over that period of time. Well, that 150 you spent adds on to the 100 you paid for it. So your cost base is actually 250, and you're only paying tax numbers between that stepped up number and the total sale price now. So often a lot of people forget that, and people aren't actively sort of tracking the costs because they're not just thinking about it. What I tell people is make sure you've got a good picture of that now, because even if it's not crystal clear for you in terms of the cost you would have paid, it's much more clear to you than it will be to, you know, your kids or somebody else down the road if they take it over, because they won't know necessarily what repairs were done and what happened sort of from year to year. So that's a big thing I tell people. Make sure you keep track of all of those costs that you've incurred sort of over the years, and you add that to your cost base. That's one piece. The second piece I was going to touch on was the use of life insurance as well. So life insurance can serve a lot of purposes, and what people use it for in the past was basically just a protection mechanism, more or less. So you know what, I've got two young kids. If something happens to me, you know, my significant other would be in a really bad spot, because then they're taking care of the two kids on their own. They've got the mortgage, they've got his education costs and everything else. So let me have some kind of term policy that I can have in case something happens to me. My family's taken care of by this insurance sort of payout, and all that still works. But what we're seeing more in the past, probably, I don't know, 7-8 years, I would say, is permanent insurance policies. So whole life, where the cost is quite a bit more to pay into these policies, but the payout is guaranteed. And what that can do is, again, the whole thing pays out tax-free on your death. That can take care of a lot of the tax liability that might otherwise arise on your estate. So let's say, again, the cottage, for example, you get a big tax liability on death on the cottage. You don't want to sell the cottage, you want to keep it in the family. You've got this huge bill to pay CRA. How are you going to pay it if you don't sell the cottage or sell something else? The answer might be, well, you've got this insurance policy. You can use that tax-free money and pay some of that down. It's also a really good way to equalize different children as well, because the amount's tax-free. And also potentially it may help you with non-resident beneficiaries. So the insurance is a nice component. And then the last piece I was going to talk about was just quickly talking about donations. So donations are something we deal with during the lifetime of individuals. And there's some strategic ways we can use donations where the benefit to the charity is the same, but the cost to you is a bit less if we structure it properly. And then we also tell people, okay, if you're thinking about making some donations on death, let's think about exactly what that looks like and what it is you're giving to the charity. So one way we deal with charities often is we say, if we can gift maybe some shares of public companies to the charity instead of gifting cash, there's a bigger financial benefit to do that on the estate side. And there's also some more flexible rules with donations on someone's passing. So what we typically see now is a little more thought in terms of specifically designating a charity in your will and how you would fund that. So you'd say, okay, it's going to be the shares of X or Y, or it's going to be cash, or it's going to be based on discretion of my executor, who can work with a tax and a legal professional on figuring out the best kind of spread for that. So that's just another piece I mentioned, because it can significantly reduce your tax burden on death if there's some kind of donation in your will that you're making. So something to just keep in mind.
That's great. So I see Kate has her hand up. Kate, did you have a question?
Hello. Yeah, I think Kody has kind of touched on it, but my question has to do with RIFs. And obviously, if one doesn't want to dispose of them during their lifetime, if in fact most of their estate is going to go to a charitable organization, obviously one would get the tax benefit there, would we not?
Yeah. So in anything you're donating it to a charity on death, you get a donation receipt for, basically, and you get that for a cash donation, or you get that for donation in kind. So if you donate, again, public securities, if you donate art, if you donate a bunch of clothes, anything like that, you get a donation in kind receipt, and the treatment is the same for the estate, basically. So the same as if you gave something to charity now, you get a donation receipt, you would also get one on death, basically. There's just more flexibility on death in terms of how we treat that, and the maximum credit you can claim on your taxes, which doesn't exist up until the year of death.
That latter portion of your comment really touches exactly. In other words, you would get presumably then more benefit within the estate in terms of tax exemption than you would if you made the gift during your lifetime.
It's potentially possible. It depends on your income during your lifetime, what the size of the donation is. But it potentially may be more beneficial on death. So we sometimes do, we look at the scenario and say, okay, what's the situation now in terms of overall income? And then what's the situation going to be in the future? What we look at too sometimes is, we might say, okay, we might make this big donation. The donation is actually in excess of your income this year, so we can't fully use it. Maybe we look to trigger a gain now on, again, let's say the cottage. We bring that into income, and then we can use the full donation credit on that sense too. So that's something we can do it during your lifetime, but it's a bit more strategic to make sure we utilize the full donation credit at that point and eat into some taxable income we would otherwise had.
Thank you.
You're welcome.
Did you, Brad? No, okay. Peter, did you have a question? I see you have your hand raised.
Yes, this is probably for Brad. It's a legal question. In terms of, and I, it's actually add on to the questions previous asked by me. It's a second marriage, and so we share in her expenses. My wife has dementia and aphasia, so she's incapable of speaking her wishes, although she can still sign her signature. Power of attorney for property, you were saying if you're not happy with the bank, you can actually move to another institution. That's interesting if they're giving you a hard time. Specifically, if we want to go on a cruise, for fairly expensive one for the two of us, the banks appear to be able to control money coming out of her account. So even though you have a power of attorney for property, are they still allowed to do that?
And it might depend also on the scope of the power of attorney. So certain powers of attorney for property, they're sort of limiting what you're able to use the funds for. And it might just be for basic, standard care rather than sort of extraordinary expenses like a cruise. So it depends to a certain extent on what the power of attorney for property itself says. And then it also might depend on what type of account it is as well. So I can't say I've come across that particular issue. So you might want to look at what the actual power of attorney says in detail.
Well, if it says that you're allowed to do anything that person would be capable of doing, doesn't that sort of open the door?
Yeah, so the bank in that case, I haven't heard of, people getting pushback like that. So, if I was, I'm sort of hesitant to give very specific legal advice about it without, reviewing the situation in more detail. But in general, when you have a power of attorney for property, the intention is that, and it's a broad power of attorney for property, the intention is that you have authority over those accounts, and that the sort of check and balance against that is that you have a fiduciary duty to the person that you're acting on behalf of. So if you were to mismanage the funds, you can be held liable. But otherwise that, you should still have access to the accounts.
Yeah, obviously you would have that fiduciary responsibility, but so if you want to not only handle this kind of an issue, but anything going forward, what should you see a family lawyer or just any broad legal firm would be able to handle this kind of thing?
Yeah, it probably wouldn't be a family lawyer. It probably just somebody who deals with powers of attorney and estate matters. And then it might just be a matter of having a bit of correspondence back and forth with the bank and figuring out exactly what their concern is and why they're, not willing to release funds for certain things.
Yeah. So you don't have to go to a specialist, in other words.
Well, yeah, like I think it's probably better to go to somebody with some estate planning background rather than going to, maybe a general litigator or something like that.
Yeah. Okay, thank you.
Louise had a question here about minimum thresholds. Is there a minimum threshold for the 1.5% for probate? After a certain amount, does it start at 0?
So the threshold is 50,000. So the first 50,000 is exempt from the 1.5%, but then after that it's 1.5%. So it's not a graduated tax. There aren't certain percentages for certain values of estate after 50,000. So if you have a $10 million estate, it's 1.5% on everything that exceeds 50,000. And just to give a bit more detail on what it's payable on. So it's payable on the value of the assets of the estate from the date of death, but only on, it's all of your assets in Ontario, but it's also on your non-real estate assets outside of Ontario. So for example, if you had a big US investment account, even though that's not within Ontario, you would be paying probate tax on that unless you would, put in maybe a double will structure where you had a separate will that was handling that US account. So that's just an example of where you might want to plan in advance and speak with a professional about ways to reduce probate going forward.
Okay. Bill was asking, do you still avoid capital gains on stock appreciation if you donate shares to charity?
Yeah, that's still the case, Bill. So that's usually a good recommendation for people to avoid is to donate shares instead of donating cash in a lot of cases. Because then you save the capital gains tax for otherwise paid, you still get the same donation credit you would have otherwise had. So all things being equal, if you told me, hey, I've got 50 grand in cash I want to donate, or 50K in securities and appreciated gain, the answer is always going to be the 50K with the appreciated gain, because you're going to save the tax you would have otherwise had to pay on that. And in addition to that, if you've got a private company, so you've got some kind of family business or whatever it might be, there's an even bigger benefit to doing it through a private corporation because of some funny rules in the act and how they work together. So it's actually really advantageous to make a donation of public securities through a private company that you own if you have one.
And I guess just to add on to that, a way that can be addressed in the will is by making sure that your executors have discretion to, so say you're saying, I want 25% of my estate to go to this person, 25% to this person, 25% to this charity, and 25% over there. You can design your will in a manner where it gives your executor discretion in terms of which assets are going to who, as long as everybody gets their fair share. So if they have that type of discretion, then in that type of situation that Kody described, they would be able to specifically choose that, the stock holdings would go to the charity because there's a larger tax benefit to that, and then that tax benefit would end up benefiting all of the other beneficiaries as well after you got the tax refund.
All right, any other questions, anyone?
I had one.
Okay, go ahead, Danielle.
Yes, I'm wondering what's the best approach in looking at coming up with a plan. I guess you would start with an estate plan and then talk to a lawyer who would then maybe, if there's legal work, like I'm the one who was asking about the property and transferring. So one of the things I was thinking of doing was transferring it to our only daughter, rental property, a house. But it's looking at the whole package, like what's the best approach and looking at our investments and our property, and just, we don't want to get hit with a whole bunch of tax. I'd like to ensure that we have funds, especially with my husband's care, who's also got dementia. So I'm just wanting to ensure that we're doing things in the right order. So starting with a plan, the estate plan, and then talk to a lot. We've already got POA and everything in order, paperwork wise, but there may be adjustments obviously based on the advice I would assume from the estate planning. That's what I'm getting from what I hear. here.
Yeah, so I guess the way you started an estate plan, I think it helps to speak with your spouse, make sure you're sort of clear on what you want to do. In your case, you also want to involve your daughter and potentially transfer some property to her.
Yeah.
So just sort of figure out what everybody wants to do, and I'm not specifically talking about your situation, but
Yeah.
other people as well. So figure out what your intentions are, and then after that, if what you have in place isn't adequately addressing that, I think it's good to talk to professionals. In your particular case, where you're looking at transferring, a capital asset to a child while you're still alive, I think in that case, it makes sense to talk to an accountant and or a lawyer about that, because that's where somebody like Kody can talk to you about the best ways to do that from a tax planning perspective.
Okay.
And then also from an estate perspective, even if you have, I guess in your scenario, I think you said you only had the one daughter.
Yeah.
So say you had two children, for example, but you wanted to transfer a property to one of your children, you might want to account for that, in your estate. So that's where, if you have multiple children or multiple beneficiaries, it can be helpful to also document what you're doing while you're still alive and state, for example, like, this gift or this transfer is intended or not intended to be a prepayment of their inheritance.
Okay. Yeah, no, that's helpful. I think, we're trying to sort out our sort of way forward with things. And obviously with the real estate boom, our property, the rental properties, and we've asked the tenant to leave, but we're, my daughter's coordinating right now, trying to get some work done there. But I'm just trying to figure, should I just transfer it over into her name, or looks like I have to pay capital gains regardless, but maybe I should do it anyway, So anyway, I just need to figure out what to do. And we have other investments as well. So it's just looking at all of that, to make sure we are in, making the best decisions and minimizing tax. My husband worked for CRA for 35 years, and I'm saying that, No, he did, but when I hear the probate and all these other fees, it's just like, I know my husband's, we want to have some funds definitely available to support what his needs are, Yeah, so.
Yeah, and usually I tell people estate planning works the best when you have a lawyer and accountant working together. And that's when a plan comes together really well, because there may be some stuff the lawyer's working on with a will, for example, but doesn't know the tax rules all that well for some specific thing. And conversely for, the accountant may not know some specific legal thing that may be throwing things offside. So part of the reason that we're doing this presentation together is my firm and Brad's firm very closely together. And that's how we find it works best for all of our clients when the two professionals work together. So I just recommend whoever you're working with, make sure that the professionals are talking to each other. So you're getting the best advice. You're not getting contradicting advice from either party.
Gotcha. Yeah.
Awesome.
No, I'm actually looking for some folks to give some advice. So, and I had a lawyer, but I'm looking at changing lawyers. So
Brad's a better lawyer.
After this, I'll send an email to everybody with their contact information if you want to pursue and ask some questions. So does anybody have any last questions? One last question before we wrap up? No? All right. Well, I am going to turn, was there a question? All right. I'm going to turn it over to CareFor's board chair, Maury Hill, just to say a last word. Maury, are you there?
Sure.
Right.
Yeah, I just thought I should say something on behalf of the board and I guess I get CareFor as well. This session was sort of phrased somewhere along the way that made it sort of equivalent to maybe going for a root canal or something, like who wants to talk about estate planning. But I do want to congratulate both Brad and Kody for, I thought, a very entertaining, very light, very accomplished presentation. You just made it very easy to, take it in. And I know it's a very, very complex topic. So I do thank you for your time and for your professionalism. And I would say, by the way, if anyone's looking for a lawyer slash accountant team, you should definitely follow up with them, because I think they've certainly shown their wares very, very well. And of course, I'd be remiss if I didn't just remind you all, if anyone's looking for any particular charitable organization to donate to by way of a legacy donation, Brad and Kody have, I think, given us all the value of doing so, and maybe have shown us that the mechanism isn't all that tricky to sort out, and it would do certainly great effect to care for, and I think also your estate. So something well worth thinking about. So again, thanks guys for your time.
Yeah, thanks for having us, and I appreciated the format. It was a nice, relaxed atmosphere, and we didn't have to put together any PowerPoint presentations or anything like that.
Yeah, great to be. Hope everybody found it informative, and everybody learned something. And everybody stayed awake the whole time.
Even between 4 and 5 on an afternoon. Well, thank you.
Great.
Thanks, Brad. Thanks, Kody. Thanks, everybody, for joining us today. Look for an email coming in the next little while. And yeah, if you have any more questions, please follow up with them. I'm sure they would be more than happy to be able to help you sort out your estate. Have a great afternoon, everybody.
All right, thanks, everyone.
Thanks, guys.
Thanks, Trevor.
Bye.
Thank you.
Thanks, Trevor.